Wait, focus.
May I please, Your Lordship?
Yes, ma'am.
Your Lordship, I beg to mention item number 82.
82.
Yes, Your Lordship, the hearing Your Lordship, if the matter be listed after 3 weeks, Your Lordship.
You're the counsel for the
Petitioner, Your Lordship.
on the prayer of 82. On the prayer of MS So, the learned counsel for the petitioner listed after 3 weeks. Okay.
Much obliged.
May it please your lordship.
Yes.
I'm filing this application, seeking your lordship's kind indulgence to permit the petitioners to continue with and at interim order to continue with the works as per the direction of the NHI this year. In the main writ petition, I'm assailing the.
What is your prayer in the main writ petition? Let us see. What is your prayer? Petition.
At page 27. One is to quash and set aside the fresh NIT, which was tendered by the NHIDCL. And the second is the quashing of the termination notice.
See your prayer D.
Yes.
Yes. If we allow this petition, we will be more or less disposing of writ petition.
Yes, but if your lordship may also appreciate a letter, allow me to just rely on this.
I know, I have seen. On the basis of that, you say that actually you are entitled to
at least complete those 5 kilometers of DBM work, which was directed by
Yes.
this year.
Lordship, in this regard, since the termination of contract is still, they have not challenged that, or that has not been stayed. So at this matter,
You want to file objection to this?
Lordship, we have tried to file an objection on this, but in the meantime,
No interim, no interim. We are not allowing any interim
Lordship,
because giving you interim will tantamount to disposing the writ petition. So we will hear the writ petition, but for this IA, you file your objection, if any.
Lordship.
Okay. What was the interim order? Not to open the bids
Yes.
without the
Without
permission
leave
of this court.
Yes. Your Lordship.
And the encashment of bank guarantee.
Yes, that's a sort of mistake.
Third, Mr. L. Iralu, the learned counsel for the applicant, and Mr.
Chasi.
So-and-so, the learned counsel for the
Sole response.
Sole respondent.
sole respondent. Stop. This application has been filed for allowing the petitioner to continue and complete the 5 km DBM of the contract work in terms of the letter dated 3/3/2023. Stop. The opposite party, the learned counsel for the opposite party, 6/4, 2 weeks time,
Lordship.
2 weeks time to file objection to the application. No notice necessary.
Lordship, it will be.
No notice necessary. Listed after 2 weeks.
Your Lordship, can the matter be fixed?
Yes.
After 2 weeks, but 5th June, 5th June. Same.
Listed on 5/6/2023.
Then in the main writ petition, the interim will be continued.
Yes, in the main writ petition. Mr. So-and-so, learned counsel for the petitioner, and Mr. So-and-so, the learned counsel for the respondents. Stop. The interim order passed earlier shall continue till the next returnable date. Before that, listed on 5/6/2023.
Deeply obliged.
Permission, I couldn't.
Yes, where is the? Where is your Joshua?
My lord, he is in court 2, court 3.
Okay, his presence will be necessary.
Okay, my lord.
Okay, his presence will be necessary because he has some explanation to do.
Okay, my lord, I'll call him. Just one.
Yes. Yes, Mr. Joshua,
Yes, my lord,
I have done my homework.
lordship,
I will give you the homework again for your part.
my lord.
Okay. You have actually made a skeletal submission that as per the second phase verification, you are entitled to compensation,
Yes, lordship.
correct?
Yes, lordship.
And you have also submitted that since the central government has paid the first phase compensation,
Lordship.
there is no question as to why the
They
central
should not
government
pay.
should not pay the second phase compensation.
Yes, lordship.
That is your, okay. Now, I have done my homework.
My lord.
So let us come one by one,
Lordship.
especially the government. Okay. During the pendency of the work, there arose a dispute between the contractor and the government. Correct? And during which a PIL was filed by one Khatovi. Correct? Have you gone through all this?
The PIL lordship, I'm not aware, lordship.
That is where the issue lies. So now you come to the affidavit in opposition filed by the state respondents.
Lordship.
Let us see that. Page 39. Let us go straight to the type copy.
My lord.
Page 39. Okay, you got
Lordship.
it?
Yes.
Page 39. This is PIL 7 of 2013. And this is filed by one Hetovi Kapo versus Union of India and others. Let us go to the operative portion of the order. Let us see. Let us come to page 43,
Yes, lordship.
the last para.
My lord. May I read, lordship?
No. You let the government read. This is your affidavit.
Yes, lordship.
Okay. The report reveals, you read from there.
The report reveals that earthwork has been done. The contractors have kept their machineries at the site. They are not able to proceed with the further construction of the road for one-off payment of the bills. In the report, it is mentioned that errors of about 540.31 crores due to be payable to the 7 respondent. It is the allegation that the first respondent is not releasing the needed funds for payments of errors and for progress of the work.
Yes.
Keeping in view the allegations in the petition, the recommendations of the commissioner, we feel it just and proper that the 7 respondent,
7 respondent is the contractor.
yes, your lordship,
Yes.
which is IL and FS Engineering House, Hyderabad, should be directed to complete the entire project within 1.5 years. The first respondent is directed to release the pending bills and unpaid dues within 1 month, and the 7 respondents shall commence the work within 1 week from now.
Yes. So the direction on disposal was that the contractor is directed to complete the entire project within a period of 1.5 years. And the first respondent is directed to release the pending bills. Okay, that was a direction in the PIL.
Lordship.
Okay, now we skip the next para and come to the project entrusted.
The project entrusted to 7 respondents is a huge project involving substantial crores of money. It is very much necessary that the project is completed within the time frame fixed by the court, and as well as the quality of the road should be checked by effective supervision over the period in which the contractor is executed. Contract
Continue.
is executed. We feel that a retired judge of this high court would be the appropriate person to deal with the aspect of periodical checks to ensure execution of the project work to be completed within the time frame, as well to look into the aspects of payments or appeals to the contractors to be in accordance with the proportion of work done, so that there should not be any underpayment or overpayment, and also non-payment, which should be the cause for the contractor to delay the execution of the project within the time frame.
Yes, please.
Shri Justice R.P. Mishra, who was a former judge of this court and presently pays at Delhi, is appointed as commissioner to supervise the execution of the contract works and also payment of bills to the contractor. The commissioner has to make periodical visits to the places where work is under execution and check and ensure the quality of the construction, along with chief engineer, PWD, NHAI, Government of Nagaland, and as and when necessary.
So the order disposing the PIL was that the contractor was directed to complete the work within 1.5 years. And the Union of India was directed to make the payment. And Justice R.B. Mishra was appointed as the commissioner to supervise the work. Okay. I am coming because actually, so that actually you know the gist of what happened before.
My lord.
Okay. Now come to page
46, your lordship.
no, you come to page 50. You come to page 50. Okay. Yes, Mr. LT, kindly read paragraph 5. This is the review filed by the Union of India
Yes.
against the order passed by the PIL, passed in the PIL. Okay,
May I
so
read,
come.
ma'am?
Yes, please, para 5.
Verify the order dated 13/10/2015 is a recent order which was passed after hearing the learned counsels for the parties. There is no error apparent on the face of the record warranting review of the same. The ground urged by the applicant cannot be a ground for review of the order dated 13/10/2015, which order had been admitted not being implemented till date, despite there being no stay order passed by this court. Therefore, we do not find any good ground to review the order dated 13/10/2015. In the result, the review petition stands dismissed.
So the review filed by the Union of India was dismissed. Okay, now come to the next. Page 52. This is the order passed by the Supreme Court. Against this order passed in review, the Union of India took up the matter to the Supreme Court. So this is the order passed by the Supreme Court. So page 52. Okay, let us. Yes, you read para 8 at page 57.
Married Lords.
There's a portion.
It is also essential for us to record some observations in respect of the claim of respondent number 7 with reference to the work already executed. It is also necessary to keep in mind the effect of the cancellation of the contract, and also the loss suffered by respondent number 7,
Respondent number 7 is
That
my
is MS.
contractor.
Mita Skytree. Insofar as all these aspects and similar allied aspects are concerned, we are of the view that the consequences emanating out of the agreement dated 3rd February 2011, executed between the state of Nagaland and respondent number 7, can only be settled in terms of the arbitration clause incorporated into your agreement.
Okay,
The
to that
same is-
extent, to that extent, para 9, page 59.
Yes. May I read your lordship?
Yes,
In view of the above, while disposing of this appeal, we grant liberty to respondent number 7 to recover its dues, if any, in the first instance from the state of Nagaland, and in case respondent number 7 is dissatisfied with the payment made it. Respondent number 7 is granted liberty to invoke the above arbitration clause of the agreement dated 3rd February 2011.
yes,
May I read? your
yes.
lordship? In view of the above, the impugned order passed by the High Court is liable to be set aside and is accordingly set aside. Having perused the arbitration clause extracted here and above, keeping in mind the pleadings filed by the rival parties and the submissions made during the course of hearing, we are satisfied in clarifying that the term employer expressed in the arbitration clause would be the appellant, the Union of India, and conjunction with the state of Nagaland, and the term contractor would be respondent number 7. Needless to mention that in case the appellant has any counterclaim, it would be open to the appellant to seek the same. In the same manner as we have permitted respondent number 7, MS Mita Skytree, to raise the arbitration clause, the appeal are allowed. Pending applications stand disposed of, your lordship.
So here, Mr. Joshua, what is important is that while actually allowing the appeal, para 12, needless to mention that in case the appellant is the union,
Yes, lordship.
the union in conjunction with the state, the employer, has any counterclaim, it would be open to the appellant to seek the same, in the same manner as we have permitted respondent number 7 to raise the arbitration clause. Okay,
Lordship.
so now come to the later dated 74, page 74. Page 74. This is the letter written by the MOT to the Commissioner and Secretary, Works and Housing Department, Government of Nagaland. Kindly read. You skip others to save time. You read clause 2.
Chief Engineer, PWD National Highway Nagaland has brought out that damages have occurred to property / environment, etc., due to cutting of hills by the contractor, and the people have claimed compensation. These compensation amounts can be claimed from contractor by raising counterclaim against him and will be dealt during arbitration process.
Yes. So the counterclaim relates to your claim.
Lordship is actually misleading
It's
because the first PIL has got nothing to do with compensation.
we are
Yes,
on record.
My lord,
First PIL, I will come to that.
my lord,
I will come to that.
lordship.
But now, on the basis of the record, we are trying to actually bring out what is what in your case.
Lordship.
Because you have only made a skeletal submission. You have not actually brought out all this to the notice of this court, nor had the government brought all this to the notice of this court. That
Lordship.
is why I'm saying
My lord.
I have done my homework, and now it's your turn to do your homework. So I'm taking you to all this,
Lordship.
okay, to show how much homework I have done. Okay, now, so actually, the state government was directed The state government was directed to raise the counterclaim in the arbitration proceeding. Now come to page 94, which is the arbitral award. Come to page 94, which is the arbitral award.
Lordship.
Okay. Now at page 97. At page 97. Okay,
Yes,
okay, you read the counterclaim number 1, 280.
yes.
That is the counterclaim submitted by the state government before the arbitral proceeding. Read the serial 280.
In this context, we also deem it appropriate for deal with the respondent's counterclaim for an amount of rupees 121 crores against the claimant on account of random dumping of excavated materials. As noted above, the respondents did not allocate a designated place of dumping of the material, an act which they were contractually obligated to do. Having failed in their obligations, we feel that the respondents cannot seek compensation from the claimant on this count, particularly when we have ourselves made reductions from the BOQ rates while computing damages in favor of the claimant. Moreover, the quantum of compensation as assessed by the respondents does not reflect the actual loss cost to the respondents. The documents relied by the respondents are various abstracts of assessments of costs signed by the Deputy Commissioner, respondent number 1. These abstracts do not indicate the cost, if any, that respondent number 1 actually spent towards removing the dumped materials from the roadside. On being asked during the course of arguments, learned counsel for respondent number 1 also admitted that there was no material on records to establish that respondent number 1 had engaged any third party to remove the dumped material on behalf of the claimant, or that the abstract of cost reflects the actual cost incurred by respondent number 1.
Yes.
281, may I read,
Yes.
Your Lordship? We wish to add that while the claimant's act of dumping on the roadside might have caused great hardship to the local public, but that cannot be a ground for us to award compensation to the respondents under the law of contract.
So the arbitral award has rejected your counterclaim of 121 crores, correct? Mr. Joshua, on the basis of the record,
Lordship,
respondent number 1 is the state government before the arbitral proceedings.
my lord.
So the arbitral proceedings had rejected your counterclaim, which the central government had asked you to file before the arbitral proceedings. Okay, so your 121 is the cumulative compensation, second phase compensation. Cumulative second phase compensation. And out of that, you are actually seeking compensation for the damages caused within the district of Zinabad. So 121 counterclaim submitted by the state government has been rejected. Okay, now come again. Yes, against this arbitral award, the state government has filed an application again before the arbitral award. Page 100. Page 100.
Lordship,
Order on application of respondent number 1 filed under section 33, clause 4 of the Arbitration and Conciliation Act. Okay,
Yes,
read from
Lordship.
para 1. Mr. LT, para 1.
Award was made on 10/8/2019 and signed copies of the award was delivered to the parties on the same day. Within 30 days of the award, respondent number 1 filed an application on 3/9/2019 under section 33, clause 4 of the Arbitration and Conciliation Act 1996, hereinafter called as the Act, with a request to the tribunal to pass an additional award vis-a-vis its counterclaim. Number one, copy of the application was supplied to the claimant's counsel. The claimant filed its reply on 14/9/2019. The tribunal has gone through the application and reply, and the same is being decided by this order. Respondent number one, applicant has alleged in the application that while passing the award dated 10/8/2019, this tribunal has rejected its counterclaim number one, considering the
No,
humanitarian
that's
aspect.
seven. Come to seven.
I'm sorry.
We may observe that the jurisdiction of the.
Seven, para seven, 102, page 102.
Yes, I'm reading from
Yes.
there. Your Lordship.
Uh,
Para seven.
We may observe.
We may observe that the jurisdiction of the arbitral award to pass the additional award can be exercised only as to the claims prescribed in the arbitral proceedings, but omitted from the arbitral award. It is an admitted position that respondent number one had submitted its counterclaim number one for an amount of rupees 121 crores on account of random dumping of excavated material, thereby causing hardship to the local public. It was duly considered and by a reasoned order rejected. As such, it is not a case where the tribunal has omitted from its award adjudication on counterclaim number one. Having no jurisdiction to pass additional award on the facts of this case, the application, which is misconceived and is liable to be dismissed.
Yes, so the
according to
second
the
application filed by the state government was again rejected by the arbitral proceedings. Okay, now after this, we come to the issue. So you are clear now.
Lordship,
You are clear now. The second phase compensation amounting to 121, which was put up before the arbitration proceedings as counterclaim by the state government has been rejected. Okay,
Lordship,
that is where we stand now. Now come to page 104.
yes, Lordship.
Page 104. This is the letter written by Mott to the chief engineer. Please read.
Sir, reference is invited to RO Mort Gauhati, letter number such and such, dated 14/8/2019, copy enclosed, intimating herewith that an amount of rupees 861,3766,627 has been awarded to the contractor by arbitral tribunal for the work mentioned in the subject above. With the approval of the competent authority in ministry, it is requested to challenge the award of arbitral tribunal in an appropriate court of law as per section 34 of the Arbitration and Conciliation Act 1996 within 3 months of the date of award with effect from 10/8/2019.
Yes, so by this letter, the state government was advised to file appeal against the arbitral award. Okay,
Lordship,
now come. Now we are on the last. Now you come to
Page 11 of my
page 11. You are right. You come to page 11.
page 11,
Para
relevant.
4, clause 18.
Yes. May I read your lordship?
You got it, Mr. Joshua?
yes, Lordship.
Yes.
That the Mort White, its letter dated 27/9/2019, had directed the chief engineer, PWT National Highway Nagaland, to challenge the award of arbitration tribunal in an appropriate court of law as per section 34 of the Arbitration and Conciliation Act 1996 within 3 months of the date of award. Thus, PWT National Highway Nagaland had filed an appeal in the Delhi High Court against the arbitral award, and the same is still pending for disposal. Thus, the respondent authority is also not sitting over the matter,
Yes.
but diligently taking measures so as to dispose the matter in the interest of all
So-
concerned.
So against the arbitral award, the state respondent has filed an appeal before the Delhi High Court.
Yes,
And the
Lordship.
matter is pending disposal.
Yes, Your Lordship.
Okay, now come to again. Yes, para 14 of the affidavit in opposition filed by the respondent number 2. Yes, page 15. Where is Mr. Muli? I think we will start imposing costs on the central government.
Yeah,
Okay,
read, Your Lordship.
yes, you read.
Page, running page 15, paragraph
Yes, yes,
14.
correct, correct.
The Mort White letter dated 27/9/2019 had directed the respondent number 5 to challenge the award of arbitration tribunal in an appropriate court of law as per section 34 of the Arbitration and Conciliation Act 1996 within 3 months of the date of the award. Thus, the respondent number 5 had filed an appeal in the Honorable Delhi High Court against the arbitral award. The Mort has also filed a separate petition in the Honorable Delhi High Court by means of an OM letter such and such. And the matter is now in sub-judice.
Okay, so both the state government as well as the Union of India, they have filed against the arbitral award, they have filed an appeal in the Delhi High Court, and the matter is now sub judice. Okay, so when the matter is now sub judice, whether this court on the same subject matter can take up this issue. Now you come to PIL, you come to your PIL. Let us see the order, the judgment passed in the PIL. Let us see.
Lordship.
Yes. Yes, you come to page 6 of 10.
Page 6, Lordship.
Yes, page 6 of the judgment.
Lordship.
Please read.
From paragraph 4, Lordship.
In the meanwhile,
In the meanwhile, the contractor asked for escalation of the contract amount. However, the same was refused by the employer. Due to the tussle between the employer and the contractor, the execution of the work stopped and the parties went for arbitration for settlement of the dispute. While this was going on, the petitioners filed a present writ petition praying for issuance of appropriate writ order directing the respondents, more particularly the Ministry of Road Transport and Highways, to pay the compensation as worked out by the state government after the joint survey was conducted.
yes, so there is no mention of the pending case before the Delhi High Court. This,
Lordship.
in this PIL, it was only when the arbitration proceeding was pending that the petitioner came before this court. But the court said, no, despite the arbitration proceeding pending, we will award. That was awarded. Now here is a question where the matter is now pending before the Delhi High Court. Whether this court can take up a matter, the subject matter of which is subjudiced before the Delhi High Court.
Lordship, subject to the consideration of your Lordship, if I may be allowed to make a submission.
Yes,
The issue starting from PIL 7 of 2013, filed by one Hetovikapo. Lordship, that subject matter is purely different from the issue of
I
compensation.
know, I know.
It was only for the completion of the road project.
Yes,
Now, in continuation to that, the Union of India Ministry of Road Transport and Highways wrote a letter dated 14 February 2017, stating that it has to be part of
see,
the,
Mr. Joshua.
yes, Lordship,
In continuation to the order passed by the Honorable Supreme Court,
Lordship,
the arbitration proceeding was filed. In the arbitration proceeding, the state government has submitted a counter proposal of 121 crores, which was first rejected by the arbitral award. Okay.
yes, Lordship,
Second, again, you had filed an application,
Lordship,
okay, seeking for additional,
by the state,
yes, the state has filed,
yes, Lordship,
seeking for additional, counter proposal,
the Lordship,
additional counter proposal.
Lordship,
That was also rejected. That
Lordship,
was also rejected. Now, against that rejection, on the advice of the central government, the state government has appealed the arbitral award before the Delhi
Delhi
High
High
Court.
Court, yes, Lordship,
And the Union of India has also appealed the arbitral award against the Delhi High Court. Now, on the same subject matter, when the matter is pending before the adjudication before the Delhi High Court, whether this court can take.
In fact, Lordship, I'm partially in agreement with your Lordship. But if my Lord may kindly appreciate, even before the Honorable Supreme Court, the issue of 121 crores for the damaged properties amounting to that amount that is 121 crores. It was never a subject matter before the Honorable Supreme Court also. Now,
Supreme Court has actually, in its operative portion,
yes, Lordship.
has stated that if the respondents have also any claim, that may be actually filed before the arbitral award, before the arbitral proceeding by way of a counter proposal. So it has stretched.
So it is the mistake
now
of the state
actually-
respondents where we have to become a victim, Lordship.
No, it's not that, but whether actually this court is actually like concerned. Because when the matter is sub-judice before if you can actually satisfy this court, that is why I am asking you to do your
No.
homework. If you can satisfy this court, that despite the pendency of the appeal before the Delhi High Court, there is no problem for this court to take up the matter. Then of course, provided you support your submission with law, then this court can take it.
If not, your Lordship,
But I think that is what is now of concern now.
whether it is to be paid by the Ministry of Road Transport and
That is
Highways.
okay, that issue is okay. What this court is concerned is when the matter, same subject matter is pending before the Delhi High Court.
I got your Lordship, but what I'm trying to say is, whether it is to be paid by the state or the union, the petitioners, they're entitled to compensation, so Lordship, if on that line.
You
American
are
dispose-
making your
yes, yes.
argument only with regard to that point of view. What about the other side? At
Lordship.
least this court should take everything into consideration.
My Lord, my Lord.
We
No,
cannot
I
just
agree
hear
with
you and pass any order in your favor. That's not
Lordship.
possible. So that's why we will call for the records of the PIL also
My Lord.
on the next day,
Lordship.
but I will not keep it as part heard now. Too long
My-
part heard. You have not done your homework. I have done mine. And I have come before this court.
In fact, Lordship, I have also done my
Yeah.
homework.
So when I did my homework, I found that all these things has to be adjudicated.
If my clients see the video proceedings, Lordship, I may be misunderstood, Lordship. I have also tried.
Let's only hope your client does not see. So this is the issue. So you kindly come prepared to assist this court as to whether, despite the pendency of the case before the Delhi High Court on the same issue, this court has the power to actually pass any order insofar as your compensation is
In
concerned.
fact, Lordship, whether I do any further research or not, rightly or wrongly, the issue which is not a concern at all, compensation issue should not have been part of the arbitral proceeding, but it was rightly or wrongly part of the arbitral proceeding, and the matter is pending before the Honorable High Court Delhi.
See,
So in that sense of the matter,
The
Lordship,
Union of India,
yes, Lordship.
on the basis of the order passed by the Supreme Court, has advised the state to take up the matter before the arbitration
Yes, Lordship.
by way of counter proposal, that 121 crores. So actually, the state government has also just blindly not taken up the matter before the arbitral process.
That is why, Lordship, rightly or wrongly,
You-
the matter
you-
is
you
not
may be
pending,
right.
so.
You may be right when you say that actually you are not concerned.
My
You
lord,
are not concerned about who is to pay me the compensation.
my lord.
My land has been damaged. And since it is the central government who has paid the first phase of compensation to the aggrieved landowners, I should also be paid by the central government. That is okay, simple as that. But going by the records is not
Yeah,
simple
Lord.
as that.
Lordship, as an officer of the court, I feel that what my lord has rightly expressed, that as I've submitted rightly or wrongly, it has become a subject matter of arbitral award and then it's now pending before the Honorable Delhi High Court.
Hmm.
So in that view of the matter, Lordship, it may not be appropriate for your Lordship to issue directions to third party and who would pay the compensation
if,
also.
the Honorable Division Bench had also actually referred to the pendency of the case before the Delhi High Court and had given some reason to pass the order in favor of the petitioner, then maybe this court could have also taken shelter under that order. But now here is a case where actually in the division bench order, nothing is mentioned about the pendency of the case before the arbitral process, before the Delhi High Court.
My lord.
So that is what is actually worrying me.
Lordship.
Of course, I thought that I will pass the judgment, but when I went through the records, I found that those things are to be decided. Unfortunately, I have not kept it as CAV, but I have kept it as
Part heard.
part heard.
Lordship.
So what is to be done? We'll list on Monday with the PIL. And you
Lordship.
also come prepared. At least
Lordship.
let us take a chance
Lordship.
if you can satisfy the
My
score
lord.
on that.
I will also do more research work, Lordship, as my lord has expressed.
I think I have also come across some judgment of the Supreme Court. But I don't know, which says that even if arbitral proceeding is pending before the arbitration, if the person seeking compensation is not a party to that arbitration proceeding, any order passed by the arbitrators will not have impact.
No binding in fact.
Something in that line I have come across. Just see that also,
I will see, Lordship.
because if
I
that
will
is
try to
there,
see.
then we can certainly see something.
My lord.
Okay.
Lordship.
So we'll list it on Monday, 29.
Lordship.
List it on 29. Until this fellow,
Muli.
Mule, tell him to come. If not, we'll impose cost. He is one of the main parties who should be apprising the court on this. Listed on 29/5/2023 along with PIL
7 of 2013,
9 of 2019.
9 of 2018. Okay. Oh, Lordship.
Listed as a fixed item, released from part heard. Okay.
Bless you, Lordship.
Your Lordship, it's a posthumous matter, Your Lordship, posthumous regularization matter. Your Lordship, it have been kept in abeyance, Your Lordship, in lieu of the Supreme Court's matter, Your Lordship. But it's been disposed, Your Lordship.
Supreme Court is disposed.
Yes, Your Lordship. Your Lordship would check the last interim, Your Lordship, last order, Your Lordship. Lordship, with the matter be listed of 2 weeks, Your Lordship, for hearing, Your Lordship.
I think once and for all, we should settle this matter.
Lordship.
Any posthumous case for regularization, the order passed by the Honorable Supreme Court is always brought in. So we have to see what is the case, what was the case before the Honorable Supreme Court and what is the case before this court?
Lordship. Lordship, with the
Because
matter,
all cases may not be similar.
yes, Your Lordship, the facts and circumstances are different, Your Lordship. Lordship, with the matter can come up after 2 weeks, Your Lordship, for hearing, Your Lordship.
Okay. You're the counsel for the,
Petitioner, Your Lordship.
on the prayer of Mr. M. Solo, the learned counsel for the petitioner. Listed after 2 weeks.
March 5.
Item 44, 175,
Yes, Mr. CT,
Applies.
what is the matter about?
Lordship, the government has filed counter and it is a pull from the blue for me,
It is a bolt
from the blue,
Okay,
for
why?
me, for me.
Why,
So-
why?
This is with regard to the appointment on the basis of landowners. And the government counter says that appointments have already been given in the past.
Okay,
So in that connection, I would like to get some instructions from my client, but I'm unable to get the instructions. So a short time may be given so that on the next day
Reply
it can be disposed of.
okay,
I would like to file a short reply.
okay. Mr. CT Jamil, the learned senior counsel, assisted by Mr. So-and-so, submits that. The learned counsel for the petitioner submits that he may be allowed a week's time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after a week.
45, 1, 5.
On the last occasion,
Yes,
government was directed to file an affidavit with regard to the order passed by this honorable court on 27/3/2023.
27.
And accordingly, they have filed the
What is
affidavit.
the order dated? 27/3. Let us see first. 27/3.
2023.
27. Let us see that. order first. 27/3/2027.
They were directed to file the affidavit enclosing the copy of the inquiry conducted by the Lok
27.
Ayukta.
I'm not getting that order.
27/3/2023.
27/3. Okay, okay. Yes, have you filed the affidavit? Why is it so difficult for you to place the
Report.
final report? Why is it so difficult? This court has directed you to place a copy of that report. Now in your affidavit, you are saying that the original final report dated so and so will be placed before this court as and when the matter is taken up for hearing. Who are you to dictate this court?
Lordship,
Who are you to dictate this court?
no. This is the report, Your Lordship.
You actually take out the relevant part. So far as this petitioner is concerned, the court is not concerned about the entire, the persons to whom you have terminated. Court is concerned about the person, about the petitioner in this case. So at least you could have done that. You are bringing all those bulky voluminous book and showing the court. At least you take out the extract from the relevant extract from that book, and then you can file your affidavit.
No, Lordship, that is there in my state counter affidavit, Lordship.
Mr. Mua, do you understand the order passed by this court? Do you understand the order passed by this court, or are you still confused?
No.
No confusion. Then do it.
No, that petitioner specific enticement by the special vigilance court is in my state counter affidavit, Your Lordship.
You please comply with the direction dated 27/3/2023. And please don't direct this court. If not, we'll summon your officers. Next time we'll call your officers if they are filing such affidavit. You are supposed to guide your officers not to file this affidavit. Will you comply or shall I call the officer?
I'll comply, Your Lordship. Few days may be allotted, 2 weeks time will be given to me.
Please do it. And you are a senior government advocate, you should be guiding your officers as to how to file affidavit. You cannot file this affidavit. Giving your own condition that we will file the report as and when the matter is taken up for hearing.
My apologies, Your Lordship. Lordship, 2 weeks will be granted to me so that I can file that.
Please, guide your officers. We'll give them time.
Lordship.
In compliance to the order dated 27/3/2023. No, not in compliance. You just cancel that. By the order dated 27/3/2023. The learned senior government advocate was directed to file an affidavit enclosing the copy of the final report dated 7/7/2011, submitted by the Special Investigation Team, Vigilance and Anti-Corruption, Kohima, Nagaland. An affidavit dated 10/4/2023, stated to be in compliance with the order dated 27/3/2023, has been filed on behalf of respondent number 1 to 6. Wherein at paragraph 3, it has been stated that the original final report dated 7/7/2011 will be placed before this honorable court as and when the matter is taken up for hearing. Stop. This court finds that the affidavit 10/4/2023 filed by the respondent number 1 and 6 does not comply with the order passed by this court on 27/3/2023. Stop. The learned senior government advocate is accordingly directed to file a proper affidavit enclosing the copy of the final report dated 7/7/2011 as ordered by this court on 27/3/2023. Listed on, when can you file? Listed on?
After 2 weeks.
Listed after? Okay, Mr. Singh? Listed after 2 weeks.
Yeah, please, Your Lordship.
Yes,
Lordship, I beg to mention on behalf of Tiba Pom Lordship,
this is item
46. Lordship, kindly grant me 2 weeks time of Lordship to file my counter reply to the affidavit in reply filed by the petitioner Lordship.
You have been making this prayer since April 2022. How can we perpetually allow you time to file your counter affidavit? Since April 2022. What is the matter about? Who is for the petitioner?
Lordship, I'm appearing on behalf of Tiba Lordship,
Okay, who is for the petitioner?
Limatushi.
You have filed your affidavit.
Yes, Lordship. To file counter reply, Lordship. To the affidavit in reply filed by the petitioner Lordship.
Affidavit in reply.
Lordship.
Counter reply. The petitioner has filed the affidavit in reply.
Lordship.
Affidavit in reply. The learned government advocate seeks for 2 weeks time to file rejoinder affidavit to the affidavit in reply filed by the petitioner. Prayer is allowed, listed after 2 weeks. Stop. It is made clear that if no rejoinder is filed, the case will be taken up on the basis of the pleadings available on record.
Right, Lordship.
Item 47, WPC 43, 2021.
Yes,
Yeah, please, Your Lordship. Your Lordship, I'm appearing on behalf of my senior Tompok Ponginer. Your Lordship may kindly grant us 3 weeks time to file our reply to the affidavit filed by respondent number 4.
Nizo, you have filed.
Yes, my lord, I have already filed. State and private respondent has already
You have
filed.
also filed. Okay. So to which affidavit you want to file reply?
Respondent number 4 filed.
State
Yes,
or
No, private respondent.
you have filed your affidavit in reply to the affidavit in opposition filed by the state?
No,
filed by
no,
respondent number 4. Affidavit in opposition filed by respondent number 4.
Not by the state.
Yes.
MS Senso, the learned counsel for the petitioner, seeks for 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the respondent number 4. Prayer is allowed, listed after 2 weeks.
Your Lordship, there is an interim, so may the interim.
The interim order passed earlier shall continue till the next returnable date.
obliged.
Item 48, WPC 75, 2021.
May I please, Your Lordship?
Yes,
Lordship, in this, case, I'm for the petitioner. Lordship, we have received instructions, so kindly grant us another 2 weeks time to follow affidavit in reply.
you have filed your affidavit.
Yes, Your Lordship.
MS Senso, the learned counsel for the petitioner, seeks for 2 weeks time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 2 weeks.
Item 49, WPC 351, 2021. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21. 21.
May I please, your lordship, I'm appearing on behalf of my senior, Tampo Pongyanar.
Yes,
Your lordship, kindly list the matter after 3 weeks as my senior is indisposed.
okay. The learned counsel for the petitioner. No, sorry. MS so makes a mention on behalf of Mr. Tongpok Pongoner, the learned counsel for the petitioner, and seeks adjournment of the case after 2 weeks on the ground that the learned counsel for the petitioner is indisposed. Prayer is allowed, listed after 2 weeks. Okay, yes.
Item 1559, WBC 19.
Your lordship, this matter may be listed after 2 weeks, your lordship. The pleadings are complete, your lordship.
52. It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be taken up for admission hearing. Prayer is allowed, listed after 2 weeks for admission hearing. Obliged, madam.
Item 16, WBC 74.
Yes, Mr. Apok,
Lordship, the matter is a very short matter. It can be disposed of.
let us see.
Lordship, in fact, the government, the state respondent has admitted the error committed while cancelling my order of regularization.
Yes. What is your case? Just let me know in gist.
Lordship, I was initially appointed as a driver casual under the Directorate of Higher Education. And after, in 2004, that was, then in 2019, a vacancy arose. I applied for my regularization because I was the senior most amongst the casual drivers. And accordingly, the department took up the matter. All procedures prescribed under the scheme were followed, and I was regularized. Lordship, in the meantime, the department, due to some typing error, they mentioned my date of appointment as 2020, not as 2004. And there the mistake occurred. And because of that, there was a query from the finance department because during that time, there was a ban on fresh appointments. So when the query was made by the finance department as to how the department has appointed, a fresh appointment was made when there was a total ban on fresh appointments. Lordship, in reply to that, the department clarified the matter that it was inadvertently done. And in fact, the date of appointment should have been 2004, not as 2020.
Okay.
So the mistake was communicated to the department. But in the meantime, suddenly there was this cancellation order where my regularization order was cancelled, and I was reverted back to my casual status by the impugned order 13-4.
Who had regularized you?
The department, after following there was a screening committee was set up. This was brought up before the BNR. They approved it, and it has gone up to the cabinet, and they have approved my regularization.
Okay.
So after this, suddenly on 13/4/2022, my regularization order was cancelled, and I was.
Who has cancelled your regularization order?
The director, Lordship.
The director of the department.
Yes,
And the regularization was done consequent to a cabinet decision.
yes.
Who is the director to cancel your regularization when it has been approved?
Lordship,
by the
in fact,
cabinet?
I'm not finding fault on the director because it was the nodal department from the secretariat who directed the directorate to issue the formal order.
Mr. Apok,
Yes.
my question is when actually the cabinet has approved your regularization,
Yes, Lordship.
it can only be undone by the cabinet.
Yeah.
Do you agree with me?
Of course, Lordship.
Yes, not by the secretary or by the directorate.
No, Lordship, I was just saying that, in fact, it was the nodal department, so the secretariat who had.
No, I'm also not blaming anybody.
Yes.
But I'm only saying that when actually your regularization was done by the cabinet, it is the cabinet alone who can undo your regularization.
Yes, Lord.
There's any authority.
Lordship, to
Okay.
that effect, there was some communication between my learned friend and the department. And this was produced before the court on 17th too. But then Lordship, a copy was also furnished to us.
What copy?
Lordship, I have filed it in my additional affidavit.
Okay, what was that? What was
Lordship, they are admitting to the fact that an advertent mistake was committed by entering the date. So there was no cause for cancellation of my regularization. That stand.
Where is that letter? Let's see.
Lordship,
Where is your affidavit in opposition?
no, Lordship, it is in my additional affidavit.
Additional affidavit filed by the petitioner. Okay.
This is a 4-page. I have annexed 2 letters which were furnished to the government and Lordship.
Please read.
Lordship, the first one, page 3.
Yes.
This is from the directorate.
Hmm.
Submission of borrowers' commands in respect of WBC 74/2020. This is the present revision. With reference to the letter number such and such, I am directed to forward herewith and instruct the instruction / borrowers' commands on in respect of WBC 74/2022. In regard to this case, the department cannot offer any justification but has to admit the fact that the order dated 3/3/2022, Lordship, this is subject to correction, was not supposed to cancel the regularization order of Shri Ranbimo Lata. Driver part was to rectify the incumbent's wise salary lease statement as on 31/3/2021. And the matter was to be forwarded to the BNR department along with the supporting information. Therefore, a draft letter for acceptance of mistake for issuing the cancellation order dated 13/4/2022 is hereby forwarded to the government advocate. Lordship, and this is the letter, the next page.
Okay.
Please, with reference to your letter number such and such, I am directed to forward herewith the instruction borrowers' comments in respect of WBC such and such. With regard to the above mentioned court case, the answering respondents are unable to reply to the borrowers' comments as it is an admitted case. The error committed by cancelling the regularization order of Shri Ranbimo Lata, which was due to oversight of the order dated 13/4/2022, in with regard with no valid intention has cancelled the regularization of the aforementioned incumbent, of which the answering respondent are in process to rectify the same. Therefore, the request you kindly to defend our behalf by admitting the error. That's very good.
What is the affidavit in opposition?
To that
1, 2,
effect,
and 3.
Yes,
Affidavit in opposition of respondent 1, 2, and 3.
1, 2, and
So,
3.
1,
Yes,
2, and 3.
yes.
Let us see what is the,
The same line, Lordship.
okay, madam, please read. You read from para 3.
That with regard to the statements made in paragraph 122 of the writ petition, the answering point begs to state that it is pertinent to mention herein that the department cannot offer any justification but has to admit the fact that the order dated 03 such and such was not supposed to cancel the regularization order of Sri Ranbimo Lata driver, but was to rectify the incumbent wise salary statement as on 31/03/2021. And the matter was forwarded to the PNR department along with supporting information. Thereafter, the cancellation order dated such and such was issued, by which the petitioner and his co-incumbent who were appointed on casual basis under the Directorate of Higher Education and whose service were regularized with effect from 03/03/2020 and 18/12/2020, respectively, are hereby cancelled and reverted back to their casual status by letter such and such dated 11 October 2021.
Let's just wait. Therefore, the cancellation order dated 13/4/2022 was issued by which the petitioner and his co-incumbent who were appointed on casual basis under the Directorate of Higher Education and whose services were regularized with effect from 3/3/2020 and 18. Which is the date relevant to the present petitioner?
13-4, Lordship.
3/3/2020,
No, that relates to the other incumbent, Lord.
18/12/2020, it also does not relate to you.
Lord, my 13-4 is the relevant date, 2022.
13/4,
Yes, Lordship.
by this order, your regularization was cancelled.
Yes,
13/4/2022, correct?
yes,
Okay. Was issued with the petitioner and whose services were regularized with effect from are hereby cancelled. I didn't get this sentence.
yes, Lordship.
Mr. Apo, can you kindly assess this quote? Just read the last 5 lines. Therefore,
Lordship, I have read it.
I'm not getting it.
Yes, I've read it 2-3 times.
Are you getting it?
I'm also,
Yes, no. Madam,
Yes.
you explain. What is this? He cannot understand, I cannot understand. So it is best, you are the author of this affidavit. Therefore, the cancellation order dated 13/4/2022 was issued by which the petitioner and his co-incumbent who were appointed on casual basis under the Directorate of Higher Education and whose service were regularized with effect from 3/3/2028 respectively are hereby cancelled and reverted back to their casual status. Right order dated. What do you mean to convey, madam? You are the author of this affidavit in opposition. You will be able to explain.
The impugn order that is it.
Your impugn order is 13/4/2022,
Yes, 13/4/2022.
by
It
which your
refers to both
regularization
the-
was cancelled.
Lordship, 3/3/2021 relates to the other incumbent, my.
Who is
Who
not
is
a
not
petitioner?
before him? Lordship. And
18/12.
2020 is my date. That was the date on which I was regularized.
So I don't get it all. And 18/12/2020.
Yes. Lordship, may kindly see the impugn order. That is at page 28 of my petition.
By cancelled.
Where I think the wording is there is some grammatical mistake, that's all, Lordship.
Not grammatical, the whole sentence. The
No.
whole sentence. Were regularized with this. You were regularized by the order dated 18/12/2020
Yes.
and thereafter cancelled by the order dated 13/4/2022.
Yes, the cancellation order relates to both of us.
Okay, the other incumbent as
Yes,
well
Lord.
as. Okay, without understanding what the government has written, I think we will have to pass the order. Where is the order regularizing your service? Okay, let's start from the beginning. Where's the order appointing you first?
Lordship, my casual appointment is
Page
page
13.
Page 13, Lordship. This is August 2004, Lordship.
Yes. Thereafter, what happens, Mr. Apo?
After I joined the next state,
Joining report. Okay.
then when the vacancy arose in 2019 on the date of the incumbent, I applied for checking for regularization.
What is your application, Mr. Apo?
Lordship, that is at page 15,
Page 15. Okay.
annexure 3.
Yes.
Along this, and then the next is the seniority list of the casual drivers.
You were in which serial?
Lordship, 7.
Serial number 7.
Yes, Lord. This
Okay,
is casual. The
Casual.
up to 1 to 6, they are all regular.
they're all regularized, no?
And I'm the senior most amongst the casual
Casual.
drivers.
Okay, okay.
And accordingly,
Yes.
on my application, screening committee was constituted and my,
This page 17.
yes, Lordship, meeting,
Where
meeting was conducted held on 21st March 2020.
is that? Minutes?
Lordship, page 17, this is
Just wait, page 18.
17, Lordship, this is,
Page 17
Yes,
is
the
the
whole-
letter.
yes, and the minutes it is at page 18.
Okay.
This is continuation, Lordship.
Yes, consider the community on the one person. The filling up of one vacancy of driver under the Director of Higher Education. Again, so and so, the committee, the work charge of city government, city and Bemolothar. Senior most scheduled driver. Okay, thereafter,
Lordship, 19 is the attendance of the screening committee.
19.
Yes. Is
Yes, okay,
headed by the director.
yes. Then thereafter,
Then 20 is the letter seeking for administrative approval.
approval for regularization also.
This
This is after the recommendation.
Yes.
Okay. And then,
The order, Lordship, 18 December 2020 is the order of regularization. That's page 21.
as per the administrative approval conveyed by the government, so and so, there is on the recommendation of the senior most random under the is ever regularized. The regulation against the sanction post numbers, so and so. The past service rendered by shall be counted for increment and pension benefit except seniority. Okay, so this is as per the administrative approval.
Yes.
Yes. Then
Then
what
Lordship,
is Sabak, what is 22?
this is the mistake where the mistake was entered. Lordship, we can see the page 24. the
Page
last
24.
The last page. This is the incumbency list of the department.
Page 24.
Yes.
Yes.
On the date of appointment, it's given us 18/12/2022.
Page 24, which serial?
Last. column.
Renbemo.
Yes.
Okay. So group with date of appointment 18/12/2022.
So
That is the date of regularization.
this is the date of regulation, not the date of appointment. My date of appointment is 2004.
2004.
Yes. So this, because of this, there was a query from the finance department as to why an appointment was made when the ban on fresh appointment was in operation.
Okay. What is that query? Have you annexed? Is it page 25?
Yes.
And well,
This is 26 August 2021.
you were therefore requested to clarify. Okay.
As regard both the regularized employee, the query was made.
Yes.
So the reply was given.
So where's the reply?
Lordship 27. This is by the director.
27. Replying to the clarification. Replying the clarification.
Lordship, submission of incumbent voice salary statement in respect of higher education regarding, with, I think, let me read it.
Yes.
With reference to your university, right? I have the honor to request you to kindly re-examine the matter of cancellation of regularization order in respect of Srimati Metomos River and Rumemo Lota under DT's office in the light of the following reasons.
Okay.
That's it. The date of appointment as submitted by this office in the incumbent voice salary statement was a clerical mistake. The actual date of appointment should read as Srimati so-and-so, we're not concerned. 2, Sri Rabimu Lota appointed on casual basis on 6/8/2004. Subsequently, the services were regularized after completing all court formalities and obtaining administrative approval. Sri Rabimu travel regularized on 18/12/2020. Both the aforementioned employees were regularized of all hands and not new appointments. That said, the finance department purchase sale had asked for the employee's date of appointment only and not date of regularization. I therefore request you to kindly communicate the same
to the finance department, purchase sale to cancel the order with letter number such and such dated 11 October 2021. As the letter was purely due to clerical error as mentioned above. Also, the regularization order of Srimati Sri Rapimu Lotha Driver does not contradict with the BNA office memorandums dated 22nd April 2020. This is for your kind perusal and necessary action. In the meantime, Lordship, this order was passed. That is page 28. Whereby my regularization was cancelled and I was reverted back to my casual status.
Hmm.
And Lordship, on the day of filing of this petition, this honorable court has stayed the operation of the order.
So you are still continuing as.
Lordship, with a gap of 4 months, Lordship. 3 months, April, May, June.
What is the gap?
April,
You were not allowed.
I was not given the scale of pay. I was given my casual scale.
XP.
Yes.
So what is your prayer? Let's see.
Lordship,
What is your prayer?
I have casual work order training. And may be pleased to state operation of the order to do such and such, and pass such order or further orders as your lordship meeting fitting proper in the fact and circumstances of the case. But pending disposal of the role, your lordship may be further be pleased to pass an order saying the operation of the this.
So if to revoke the order of cancellation. So if this court orders, revokes the order of cancellation dated 13 April 2022,
Yes,
then your gap in service automatically ends.
it
Is
should,
it?
lordship.
It should.
It should, lordship, if your lordship we kindly mention that.
You have not prayed for that. That's what I'm.
Lordship, I'm making a verbal prayer.
That's why. You have not made it in your prayer, so I was just asking you to go to
Lordship,
your prayers.
The consequential benefits should follow.
So once it is revoked, you will be deemed to be in regular service
Yes, lordship.
from the date of the cancellation of the.
From the date of my regularization. Lordship. In fact, from 5th May 2022, the stay order was in operation, lordship.
5th May.
Yes, because that was the date.
So between the cancellation and the stay order, there is a gap of 3 months. What you're saying? There's a gap of 3 months.
3 months where I was not paid my regular salary.
You were only paid the fixed
Casual,
pay.
casual status.
Yes, ma'am. What is your submission? Let us see. Additional responsibility. So without even, if you have admitted your mistake, without even filing your affidavit, you could have actually rectified the mistake by a formal order, and then you could have allowed him to continue. Huh? Correct. It was not necessary for you to file an affidavit. An affidavit will be filed only when it is contested. Here is a question where you have admitted your mistake, and you have actually stated that the order cancelling his regularization was by mistake. So from the office itself, you could have actually passed the necessary orders. MS, Mr. Apok Pongoner, the learned counsel for the petitioner, and MS Chang, MS Sabong Chang, the learned state government, the learned state council. We'll pass the order. Your Lordship. Okay.
Item 61, WP 76.
May I please, Your Lordship?
Yes.
Your Lordship, I'm on behalf of my senior, Mr. Gauhati for Union of India. We have
Yes, Mr. TB. What is the matter?
Your Lordship, the petitioners agree by the cancellation of offer letter appointing the petitioner to the post of constable in the CRPF, Your Lordship. Now, there was some subsequent development after filing of the writ petition. So and in the first writ petition, the respondent, they already filed a counter affidavit, Your Lordship. But I have filed an amended writ petition, bringing on record the subsequent development. So in that, they yet to file a counter affidavit.
In the recast.
Amended, recast petition. This thing.
Your Lordship, we are yet to get instructions, so kindly give us 3 weeks time to file our affidavit.
Okay, tell Mr. Yangawati to take steps, okay?
Yes.
MS so-and-so makes a mention on behalf of Mr. Yangawati, the learned CGC, and seeks adjournment for 3 weeks for filing the affidavit on behalf of the Union of India
In the recast petition.
in the recast petition. Stop. The prayer is not objected to by the learned counsel for the petitioner. Listed after 3 weeks. Okay. Just excuse me for 2 minutes.
Article 62, Article 69,
62.
Meet this, your lordship. Your lordship, I beg to mention item 62 on behalf of the constable petitioner. Your lordship, if 3 weeks.
Whether the state has filed counter affidavit.
Yes, your lordship, we are
Status
yet
file.
to file a reply. Your lordship.
Oh, okay. Now, 18/5/2023, state respondents has not filed counter affidavit. Not filed. No, this is affidavit in opposition. This is respondent number.
Respondent
respond-
number
yes, yes,
3,
yes.
your lordship.
Okay. Okay. MS and so. The Landowner counsel for the petitioner. 6 for 3 weeks' time. To file affidavit in reply to the affidavit in opposition filed by the respondent number 3. Prayer is allowed. Listed after 3 weeks. Okay.
Mr. President.
Article 63, Article 116.
Yes.
Lordship, I beg to mention on behalf of S. Temzen, due to his personal difficulty, he could not appear. On his instruction, I pray for the matter to be listed after 3 weeks.
Have you filed your affidavit, Mr. Bongchal? Have you filed your affidavit?
Lordship. Lordship, I'm appearing on behalf of Tipa Pum, Lordship.
Okay, you're filed. Mr. So-and-so makes a mention on behalf of Mr. Estamjan, the learned counsel for the petitioner, and seeks adjournment of the case for 2 weeks on the ground that the learned counsel for the petitioner is indisposed. Prayer is allowed, listed after 2 weeks.
Item 64. WPC 170.
May I please, your lordship? Your lordship, I'm appearing on behalf of my senior Tompo Convener for respondent number 6. Your lordship may kindly list this matter after 3 weeks as my senior is indisposed.
Okay. MS so-and-so makes a mention on behalf of Mr. Tongpok Pounder, the learned counsel for the respondent number
6.
6. And 6 adjournment of the case after 2 weeks. On the ground that the learned counsel for the petitioner is indisposed. Prayer is allowed, listed after 2 weeks.
Item 65. WPC 228.
May I please, your lordship?
Yes,
Lordship, I'm appearing on behalf of my senior Gauhati CJC. Lordship, we have received instructions, so kindly grant us 3 weeks time to file our affidavit in opposition.
Lordship, I am for the respondent 3, 4, and 5.
okay.
Lordship.
Yeah, file your affidavit. Mr. Nangami.
Your lordship, in fact, this is something to do with the payment of the pending bills, which relates to the central scheme, your lordship. So if the CGAC can, lordship, file an affidavit, I think that will suffice, your lordship.
So you have not received the fund from the central government
Lordship.
in respect of the scheme.
Lordship. In fact, if you see the lordship, from the first installment, documents that is being placed as one of the annexure, it's very clear.
Okay,
It is very clear. It's under the Donor Ministry, your lordship,
okay.
who are supposed to release the fund, and then we are just a disbursing agency. your
Disposing
lordship.
agency, okay. You have not filed your affidavit, ma'am. You have not filed your affidavit. We grant them 2 weeks' time, okay?
Yes.
MS so-and-so makes a mention on behalf of Mr. Gauhati, the learned CGC, and seeks adjournment of the case for 2 weeks for filing affidavit in opposition on behalf of the state respondents, on behalf of respondent number 1 and 2. Prayer is allowed, listed after 2 weeks. Yes, Mr. Nangami.
Lordship, I have filed my counter affidavit, madam.
And
Okay,
may I please, your lordship? Lordship, I'm appearing on behalf of Mika H. Aye, counsel for the petitioner.
who?
Mika H. Aye,
Mika,
who is indisposed.
Mika H. There's so many councils.
Yes, lordship, but
So many councils.
she's the
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
lordship, she's the counsel in charge for this case. She's
So where is Mika? Yeah.
she's indisposed. So kindly list this matter after 2 weeks.
What is the case about, Mr. Nangami?
Lordship, it is about the overstay of in service and then the recovery.
Recovery. What was the petitioner working as?
He retired as a PA, political assistant to DC, your lordship.
What is political assistant to DC? Grade 2, 3, 4?
It should be grade 1, your lordship, because they are given their government vehicle.
Grade 1.
Yes.
Have you actually like clearly brought out that in your affidavit in opposition?
Lordship, what happened here is, your lordship, the petitioner during the overstay period of 3 years, the petitioner was overstayed for a period of 3 years. Now, in that overstay period, your lordship, the petitioner was promoted,
Okay.
During
that overstay.
Yes, during that overstay.
From
From Dubasi grade.
grade 1 to selection.
Yes, my lord. Now, your lordship, the department have sent for condonation of that overstay period. The
Okay.
department has compiled everything and sent it to the PNR for condonation of that overstay period. The PNR has brought out a notification that it can be condoned. However, it is subject to the approval of the cabinet.
Okay.
Now, your lordship, it was placed before the cabinet by preparing a cabinet memo. The cabinet declined, your lordship. So our point of argument is, your lordship, the cabinet has rightly declined for the fact that if the condemnation period is not declined, then, your lordship, what will happen is that the illegal promotion that was, or the wrong promotion that was given to the petitioner during that overstay period will remain. And therefore, the petitioner will draw a pension. He is not at all entitled to. That is the ground we have taken.
Has that been brought to the notice of the cabinet?
Yes. Because the petitioner was promoted during that overstay period, your lordship.
Yes, so if the overstay in the post of PA,
Yes,
if that is recovered,
yes,
then this petitioner must enjoy the pension of PA.
yes, your lordship. So if the cabinet decline, allow the overstay period, your lordship, then in that case, the petitioner will be retired as PA to DC and also will enjoy the pension of PA to DC, which actually, your lordship, is a wrong promotion given to him because of overstay of period. Not only that, your lordship,
No, what was the decision of the cabinet?
decline. Just straight, your lordship.
So decline means actually the petitioner gets the benefit of PA.
No. As Dubasi grade 1. Because
The excess pay was drawn in which post?
PA to
PA to DC.
yes, my lord. PA to DC. And that PA to DC, your lordship, was given to him during that overstay period. It was wrongly given to him, your lordship.
So the government now wants to recover the excess payment which was given to him as PA to DC.
Yes, my lord. Not want to recover, but your lordship, an order has been passed for the recovery, your lordship.
For the recovery.
For the recovery, which is under challenge, your lordship. This is the second round of litigation, your lordship. In fact, the first round of litigation, they have not challenged the cabinet decision. So they have withdrawn.
Okay.
Now they are challenging that, your lordship.
Yes, besides the fact of the case, whether actually the case of the petitioner falls within the decision of Rafiq Masih's case.
Yes, your lordship. Yes, however, your
Rafiq
lordship-
Masih,
Yes.
it has given certain criteria
Yes,
as to when recovery can be made and as to when recovery cannot be made.
yes.
Anyhow, let your friend come, Mika. Mika, okay? Let her come. Well, listed for admission hearing. Okay,
Yes, lordship.
after 1 week,
2 weeks.
2 weeks. MS so makes a mention on behalf of MS or Mr. MS
Mika H.I.
Mika H. IME and seeks adjournment of the case on the ground that the counsel leading the case is indisposed. Prayer is allowed, listed after 2 weeks for admission hearing. Okay.
Deeply obliged. ma'am.
Yes.
May you please, your lordship.
Yes,
I'm yet to receive instruction. I may be given 3 weeks time to receive instructions.
Okay, we give them.
Yes,
MS Lucy, the learned senior government advocate, submits that she may be allowed 2 weeks' time.
3 weeks, your lordship.
She may be allowed 3 weeks' time to file affidavit on behalf of the state respondents. Stop. The same is not objected to by the learned counsel for the petitioner. Listed after 3 weeks.
Item 68, WBC Q38
May I please, my lord?
Yes.
Lordship, here in this matter, your lordship may kindly grant me 3 weeks' time to file my counter affidavit. Your
Where is
lordship,
the counsel for the petitioner?
lordship, they have contacted me and then they have expressed their difficulties to attend the court today, your lordship.
Okay, we show them absent. None present for the petitioner. Mr. N. Angami, the learned, the learned senior government advocate is allowed 3 weeks' time to file the affidavit on behalf of the state respondents. This is after 3 weeks.
Deeply obliged, my lord.
Yeah, please, my lord.
Yes.
My lord, we have received the affidavit in opposition from the state government.
Okay.
Lordship, they are disputing some facts. So we need to file one comprehensive affidavit. So some time may be granted.
Affidavit
Lordship.
in reply.
Yes, lordship.
Mr. So-and-so, the learned counsel for the petitioner seeks for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 2 weeks.
Much.
Item 17, 71, 73, WBC 20.
Yes, Mr. Ma.
Lordship, on the last occasion, this matter was fixed for admission hearing, Lordship. However, Lordship, I'm led by my senior, Mr. SSD. Lordship, he has some difficulties, Lordship.
Okay.
Even on the last occasion, I've made a submission that he may not be available in the month of May, Lordship. It is my respectful submission that if the matter can be listed in the month of June, Lordship, preferably second week of June, if Lordship, it's convenient for this honorable court, Lordship.
Mr. Taka, this relates to the yes, video RDO's case.
Actually, the issue is this. Lordship, Lordship delivered a division bench judgment. Now, if your Lordship recollects, tentative seniority list was challenged in the previous case without challenging the basic regularization observation orders.
Correct.
And it was the stand of the petitioners that it is not necessary to challenge the basic orders. So, my lord, the learned single judge passed an order that without challenging the basic order, the consequential order cannot be challenged.
Correct.
That judgment was reaffirmed by your lordship.
Correct.
In the division bench.
Correct.
Read Appeal 11 of 2022. Now, lordship, thereafter in compliance with the direction of this honorable court, final seniority list is published.
Oh.
Lordship. Now, my lord, the petitioner has filed 3 writ petition. The first writ petition relates to challenging the basic orders. Secondly, the second writ petition is challenging the tentative seniority list, which was a subject matter in the writ appeal. Third is the lordship, final seniority list is challenged. Now, my lord, the judgment of this honorable court in writ appeal 11 has attained its finality because no SLB filed. That is the issue, lordship.
Okay.
So, my lord, the issue of waiver, constructive res judicata and delay comes into play. Now, my lord, I filed my affidavit in opposition in the month of January. Then my learned friend, the counsel for the state, he had filed the affidavit in opposition by second week of March.
Mr. TB is for the state.
Yes. Since then, Lord, my lord, since then, the petitioner has been praying for filing reply affidavits since the second week of March till date. Now, my lord, on 24th, Lordship may kindly see the order. 24th April,
April, Lord.
24/4/2023. My lord, I am reading from the second paragraph.
Yes.
Mr. Solo, the learned counsel for the petitioner has prayed for further time for filing reply affidavit, which is objected by Mr. Such and such. Then the counsel for the private respondents mentioned that ample time has been given to the petitioner for filing reply affidavit and the final chance may be given. The learned counsel for the petitioner is given 2 weeks time for filing reply affidavit, failing which this matter may be listed for admission hearing. Then list on 9/5/2023. So, my lord, failure to file reply affidavit, the matter to be listed for admission hearing. Then, lordship, you kindly see the order on 9/5. My lord, the second last paragraph. Since the counter affidavit by the respondents are stated to have been filed as far back as in the month of January 2023, let this matter be fixed for admission hearing on 22nd May, as prayed by Mrs. Such and such. The petitioner in the meanwhile may file reply to the counter affidavits filed by the respondent if so advised. List accordingly. At the next date, the order passed by this court on 24th April 2023 may also be considered by this court.
Yes, Mr.
Lordship, the affidavit has not been filed, Lordship. Altogether in this 3 read petitions, there are altogether 6 affidavit in opposition filed by the state as well as the private respondents, Lordship.
6.
6, Lordship.
2 to each.
2 to each, Lordship.
Okay.
And we are in the process to file reply, Lordship.
Lordship, the issue is only the legal issue. It's a pure question of law. So once one affidavit in the reply affidavit is prepared, because the crown again is identical. So once a reply affidavit is prepared, it will be copy paste for the rest. So sufficient time has been granted. Actually, we came prepared. Since there was no intimation, we came prepared for admission hearing today in terms of the order.
So, Mr. Moore.
Lordship, if this matter can be listed in the month of June, Lordship,
Okay,
second
we
week
give
of
them
June,
one more
Lordship.
chance.
My lord,
We give them one.
if that is so, my lord, if that is so, then making it very clear that a date may be fixed and on that day, with or without the reply affidavit.
Of course.
Otherwise, my lord, it will.
Yes. Anything, Mr. TB?
I fully endorse.
Okay, so we fix it
Lordship,
as per your
Lordship.
convenience, since
Lordship.
the senior counsel is an outstation lawyer,
Lordship, Lordship,
but with a rider,
Lordship,
that if on that day,
Lordship,
no affidavit is filed, the admission hearing shall proceed.
Lordship,
Yes.
Okay,
Lordship.
so when do you want?
My lord, another issue.
Yes, please.
In view of the pendency of the writ petition, the promotions of the respondent has been stopped for the last 6 months.
Is there any stay
Yes,
from,
there are vacancies. We are in the zone of
no,
promotion.
whether there is any stay from the court?
No, there is no,
No,
but as a
there's no
matter of
state.
propriety, lordship, when all the department are having, as a matter of propriety, they have not processed, though there are clear vacancies. There is an urgency. That's how we have been pressing.
Otherwise, there's no stay, Lordship.
Mr. TV can advise the government that there is no stay.
Lordship, but as senior counsel, propriety, your lordship, since the matter is pending.
Because, my lord, now the prayer or the writ petition is the prayers to quash and set aside my initial orders
Initial orders.
and
correct.
delay our dance from the
role of
from
the
the role-
department.
from the role of the department. So when that kind of a petition is filed, whether, my lord, the department will have the guts to give promotion, that also is there. And
Yes, Mr. Moa, if I think the petition has really raised some issues,
Exactly.
which
agree, Lordship.
makes it difficult for the department to act very
Lordship,
promptly also.
Lordship.
So I think you
We'll
will,
make an interview that the matter will be heard, Lordship, in the next date.
Mr. Moa. Jamir,
my lord, may I bring that let the matter be listed on 5th June, Monday?
Also, if this honorable court may accommodate on 12th, that is also Monday, Lordship. Meantime, we will make,
Mr.
we'll file a reply, Lordship.
Mr. Day has always some,
My
some,
lord, only on the condition that my friend will keep his word.
yes, yes.
Because my lord, on the time, on the 12th, again, if some another excuse comes among friends,
no,
my
no,
lord, we find difficult.
We'll make an interview, Lordship.
Because my lord, we have over accommodated. I think you should not.
I'm grateful, Lordship. I'm
Mr.
grateful.
Moa Jamir appears on behalf of Mr.
SSD. Lordship.
SSD, the learned senior counsel for the petitioners, and seeks adjournment of the case for filing affidavit in reply to the affidavit in opposition filed by the state as well as the private respondents.
Sorry, lordship, may kindly reflect the two earlier orders.
Yes. Mr. Takamasa, the learned senior counsel, assisted by Mr. So-and-so, the learned counsel, and Mr. T.B. Jamir, the learned counsel for the state respondents. Vehemently objects to the prayer for adjournment of the case. Which are the two orders?
24th April and
24th,
9th May.
9th May, Lordship.
9th, 24, 9th. Stop. This code. Around 24/4/2023. Granted 2 weeks time to the petitioner for filing affidavit in reply, filling which it was ordered that the matter will be listed for admission hearing on 9/5/2023. Stop. Stop. On 9/5/2023. When the case was listed. This court had made an observation that on the next date fixed, the order passed by this court on 24/4/2023 shall be duly considered.
Granting further time for filing it.
Stop, despite the order passed by this court on 24/4/2023 and 9/5/2023. The learned counsel for the petitioner again seeks for time to file affidavit in reply. This court, in view of the earlier order passed, is in fact not inclined to grant any further adjournment for enabling the petitioner to file affidavit in reply. Stop. However, in the interest of justice, one last opportunity is given to the petitioner to file affidavit in reply. Failing which, it is made clear that on the next date fixed, the matter shall be taken up for admission hearing, either with or without the affidavit in reply filed by the petitioner. Listed on 15/6, 12. Listed on 12/6/2023.
Lordship.
Okay.
As read for by the
Listed on 12/6/2023 as prayed for by the learned counsel for the petitioner.
Well, let it be a fixed item.
Obliged. Much obliged, Lordship.
Item 73, OPC 337,
Lordship,
Yes, ma'am.
I'm appearing on behalf of the petitioner. Lordship, if 3 weeks time will be given to file a reply,
For,
reply, Your Lordship.
okay. Mr. Moore, you have filed your affidavit?
Yes, Lordship.
Okay. We give them time. The learned counsel for the petitioner is allowed 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents, listed accordingly.
Your Lordship,
Yes, yes.
sorry, there is an interim in item 62. Your Lordship.
In item 62,
Yes, which I mentioned.
item 62, the interim order passed earlier shall continue till the next returnable date.
Okay. Lordship.
Yes.
item 74, OPC that really.
Yes.
Please, Your Lordship. In my prayer, I have not specifically prayed for appointment to the said post of office assistant. I've prayed for appointment to any grade 3 post in a department. But and my lord, as according to reliable resources, the vacancy of office assistant in the school in which my father served is still lying vacant. So I may be allowed to amend my petition and pray for appointment to the office assistant post. Since I have a degree in
What-
computer application,
What is your prayer in this case? What is your?
I'm seeking appointment under the completion scheme
Under commission.
to grade 3 post.
Okay,
Since I've done MA and I have a degree in computer application,
okay,
but
okay.
now a post of office assistant is lying vacant for a long time. That
Okay.
I wasn't aware at the time of filing. So I may be allowed to amend my petition and pray for the post of office assistant.
Okay, okay. Mr. So-and-so, the learned counsel for the petitioner submits that he may be allowed to file an application for amendment of the writ petition. Prayer is allowed, listed after. When can you file the application?
3 weeks, my lord.
Listed after 3 weeks on a date to be fixed by the registry.
May this, my lord.
Yes, please.
My lord, today the learned counsel is present. He has been listed again for interim hearing, lordship.
Yes,
Yes, Your Lordship, I've intimated the department, but I have not received any instructions. So with regard to the interim prayer, I leave it to you, Your Lordship.
May I refresh your lord's memory?
you file your affidavit first. Okay, because actually so long as your affidavit is not forthcoming.
My lord, my learned friend can file their affidavit, comprehensive affidavit, and we can dispose it off, lordship. It's a simple matter, but in the meantime, the interim may be granted, lordship.
You don't have any instruction also on the interim.
Yes, Your Lordship.
Yes, lordship. Lordship, on the face of records, it may be considered, lordship.
When can you file your affidavit, Mr. Ayemi, Ms. Ayemi?
Your Lordship, 3 weeks time may be given.
MS AIME, the learned government advocate, 6 for 3 weeks time to file affidavit in opposition on behalf of the state respondents. Stop. It is further submitted that no instruction has been received as regards to the interim order passed by this court on 18/5/2023. Stop. 3 weeks time is accordingly granted to the state respondents to file the affidavit in opposition. Stop. The interim order passed on 18/5/2023 shall continue till the next returnable date, listed after 3 weeks.
Much obliged, Lordship.
Item 76, 77, 78, 79. WPC 57, 2030.
May I please, Your Lordship?
Yes.
Lordship, here, the leading counsel, Mr. City Jamir, is on legs in the next court. So
Yes.
if the matter may be kindly. passed
Who is
on-
for the other side? Who is for the other side? Who is for the government? This 57, 2013. This is 2013 matter.
Yes, Lordship, actually, this was sub-judice in Supreme Court. so-
Okay, it appears from the regular. Was dismissed for non-prosecution. Who is the state counsel here? Any of the past? Oh. Is it a transport case from Gauhati?
It's kept pending because of the acceptance.
Yes, Miss Ayemi.
Yes, Your Lordship.
Who is appearing? We are finding that Mr. TB Jamir was appearing for the state.
Your Lordship, let the matter come up after 2 weeks. In the meantime, we'll see who is handling this matter.
We will record your name after 2 weeks if you are not there. Or if no action is taken. and by which order this case was directed to be listed after the disposal of SLB by the Honorable Supreme Court? By which order? No, this is not the order passed by the court.
Your Lordship, item number 79, WPC 65, V. Jimo is appearing for the state, Your Lordship.
B. Jimo.
Yes, Your Lordship.
Item number
79, WPC
79.
65 of 2018. It is
item number. Third MS so the learned counsel for the petitioner, and MS AIME, learned counsel, appearing on behalf of Mr. V. Jimomi, the state counsel, the learned state counsel. So by the order dated 24/10/2018. The three writ petitions, namely WPC 105K 2013, comma, no, the two, please read. The two writ petitions, namely WPC 105 of 2013, and WPC 57K of 2013 were directed to be listed after the disposal of SLP number 11964/2012 and 11965/2019, pending before the Honorable Supreme Court. Stop. By the order dated 6/3/2020, the SLP number SLP within brackets C number 11964/2012 and SLP within C number 11965/2012. Were dismissed by the order dated 6/3/2022. No. This SLP is still pending. Who has written this? See? Are there orders? Is there? No? By which order? 6-3. Disposal date 6-3. 6-3. No, but 6-3 does not show. 2 weeks time, 2 weeks further time as a last chance is granted to the learned counsel for the petitioner to cure the defects in the application for withdrawal of SLP, failing which the SLP shall stand dismissed for non-prosecution. See? Automatically without further reference. So it is not dismissed. Where is our friend Mr. Siti Jamir?
Lordship is on legs in court number 3. If your lordship may kindly pass over for a day or.
Yes, kindly tell your senior to have a look at the order passed by the Honorable Supreme Court. It is, as per this order, it is not disposed. Whereas as per, what is this? As per the status, this as per the status in the. As per the status in the CIS, it is shown dismissed, warrant of prosecution. Dismissed for default, warrant of prosecution. But as per the order passed by the Honorable Supreme Court on 6/3/2020, only the last chance was given to the petitioner to cure the defects. There is no mention of any disposal. Cancel everything. Cancel everything. MS so submits that Mr. C.T. Jamir, the learned senior counsel for the petitioner, correct,
Yes, Lordship.
is on his legs in court number 3. And therefore seeks adjournment of the case for a day.
For a day, Lordship.
Listed on, what is tomorrow? 23/5/2023. Listed on 25/23/5/23. Stop. Mr. C.T. Jamir, the learned senior counsel for the petitioner, as well as Mr. V. Jumami, the learned state counsel, shall apprise the court on the status of the case in SLP 11964, SLP within brackets civil number 11964/2012, which is pending before the Honorable Supreme Court. Kindly tell V. Jimomi also to go through this. And please tell our friend C.T. Jamir
Yes,
to come and apprise this court about this pendency of the case in the Honorable Supreme Court, okay?
yes, Lordship.
Okay.
I just look
Yes. What do we do today? Give me some solution.
Yes, Lordship, I leave it to your Lordship, whether it can be taken in the second half or maybe pass over for a day.
Senior advocate
Since
is
my
before
senior
the
is on next.
court on his leg.
Second half. Miss Santi,
We can-
you will be there, madam. Second half. Okay. Let us take up this in the second half, okay? At least let us. Yes.
Which means-
What is this?
This matter was taken up by your lordship on last two occasions. But order dated 31/1/2022.
What is the matter about?
Your Lordship, we are seeking appointment on basis of land ownership here, Your Lordship. On the last occasion, Your Lordship, just a moment, Your Lordship. On 16/2/2023, Your Lordship, the matter was heard and then an opportunity was given to me, the petitioner, to file an affidavit.
By which order?
16/2/2023.
16 to.
Yes. To file an additional affidavit.
So what happens now?
To place into record that.
Have you filed?
No, Your Lordship.
Why?
Your Lordship, I've talked with my client here, the petitioner. And then, Your Lordship, it has come to his knowledge that one of his maternal uncle has informed him that his father may have been appointed once in the 1970s time. So this writ petition was filed on the basis that no appointment was given to the petitioner's family. And the petitioner, his elder sister, they do not have any knowledge about the appointment. And the mother of the petitioner and the father has also expired. So without knowing that fact, this writ petition was filed, Your Lordship. He is the landowner, however, now we have come to know that he may have been appointed. There's no pensionary benefits or anything which the family is enjoying also, Your Lordship. So they do not have any knowledge about the appointment. So I would pray that this writ petition may be disposed of on the second prayer of on the prayer that the post may be advertised, Your Lordship. This post, because the private respondent's father has also served, has also been appointed on the basis of land ownership, and twofold prayer have been made here. So I would pray that this
Last time you have made a submission that you
yes, oral
forgo.
submission was made here.
You forgo
Yes,
that first prayer.
yes, Your Lordship.
Who is in the post? Mr.
The
Dumont,
private respondent.
you are in the post. He may not lightly agree to what you are submitting.
Lordship, in the writ petition, they have made a specific statement that none of the family members has been appointed.
So why have you not filed this affidavit, which the court has directed you?
Because it was to bring to record that he was not serving, Your Lordship.
Whether he was the father or not? Is it?
Father or not, Your Lordship, the name.
Mr. Zat Kulnu, Learned Counsel for the petitioner, has submitted that Mr. Vinholule, whose name appears in the joining report dated 1/4/1976 and the order dated 25/5/1977, is not the father of the petitioner. However, such denial by way of oral submission has not been reflected in the additional affidavit filed by the petitioner pursuant to the order of this court dated so and so. In that view of the matter, the learned counsel for the petitioner shall file a proper affidavit denying that the name Vinholule appearing in the joining report dated so and so and the order dated so and so of the government affidavit is not the father of the petitioner. This evidence shall be filed within a period of 1 week time. You file. You file. Or else we'll pass adverse order against you. One of the landowners have been appointed.
Yes, sir.
And you are also very hesitant to file your affidavit on the directions of this court. There's something wrong, horribly wrong with you.
Your Lordship, that's why we are admitting, in a way, we are admitting, Your Lordship, that our father.
Your prayer for withdrawal, your prayer to advertise the post cannot be so lightly just taken into consideration. Either you withdraw or you file your affidavit, or else we pass adverse order against you.
Then a week time may be granted, Your Lordship. Just a week time.
And we will pass an order that if no affidavit is filed,
Yes, Your Lordship.
we will impose substantial cost.
Okay, Your Lordship.
That'll be the condition.
Okay,
Your
Lordship.
time. Okay,
What, either to withdraw or to file?
that is up to you.
Okay, Your
But
Lordship.
for this court, the affidavit is more important.
Okay, Your Lordship.
Okay, Mr. Lima? Okay. Heard Mr. Zad Kulnu, the learned counsel for the petitioner, and MSAIME, the learned government advocate for the state respondents. Stop. Also heard Mr. Limawabang, learned counsel for the respondent number 4. Stop. By the order dated 16/2/2023. The learned counsel for the petitioner was directed to file a proper affidavit denying that the name Vinolule appearing in the joining report dated 1/4/1976 and the government and the order dated 25/5/1977 within bracket annexure 2A and annexure 2B close bracket of the government affidavit is not the father of the petitioner. Stop. The order dated 16/2/2023 has not been complied with by the learned counsel for the petitioner by filing the said affidavit. The learned counsel for the petitioner is granted
A week's time, Your Lordship.
7 days time to file the affidavit in compliance to the order dated 16/2/2023. So 16/2/2023. Stop. It is made clear that if on the next date, if on or before the next date, no affidavit is filed, substantial cost shall be imposed on the petitioner. Listed on, give a date.
29, Your Lordship.
Listed on
29.
29/5/2023.
Much obliged.
Okay.
Release from court, release from court. Which one?
Civil judge, junior division. Our sender from civil judge, from court of civil judge, petition, remember that. Anything procedure it's in the main floor. And then we got the
And nobody is going to come and then comparing things. There is one ANR. That's I know was bad. The other part has been disposed of. This is why I want to main case order was taken. Now, close me here, huh?
I'm extremely sorry. I had some guests, so. Yes, Mr. Siti, you have to assess this court, what to do.
We are in a learning process, Lordship. After the life of election is over, everything is over. Now we are realizing that one fatal mistake we have committed. We are wondering how, without any order on completion of the notice on respondent number 2, the trial has been commenced. I'm also wondering myself how that was done. In fact, it should be me who should insist for completion of the notice. Normally in an election petition, the person who is representing the respondent,
Correct.
he take abundant caution to take all the steps are being completed and the trial should commence. But then trial has already been commenced, and before conclusion of the trial, the life of the election got over.
Correct.
Now, actually, everything has been come to an end. Now we are confronted with some technicalities, how to bury this. But my respectful submission is, since the life of the election has already been over, and the purpose of the filing of this election petition is during the subsistence of the tenure of 13th Nagaland Legislative Assembly that has already been closed, come to an end, and the new assembly has already been commenced. So in view of that, there should be no difficulty to close this case. And then subsequent steps for publication in the Gazette that will follow in terms of section 111.
Let's see that RP Act. That's section 108. 108.
They have filed the application under section 109
Withdrawal.
and the implication of withdrawal, Lordship will find it section 111.
So section 109 is followed by section 110(3).
Yes.
110(3).
Yes.
Correct.
Yes.
In the High Court section, especially 110 clause 3B.
Correct, Lordship.
The High Court shall direct that the notice of withdrawal shall be published in the official gazette. So who is to be directed? That is the issue. Whether the High Court registry or the Election Commission.
Registry will intimate.
The High Court shall direct that the notice of withdrawal shall be published in the official gazette and such other manner. Yes, madam, you were making that submission about the withdrawal.
Your Lordship, in other similar cases, Your
Correct.
Lordship, yes, the petitioner can also publish in the newspaper on the direction of the Honorable Court.
No,
Lordship.
that is there.
Yes,
Published in the official gazette and such other manner.
yes, Your Lordship.
The wording is not or.
Yes, and in the newspaper. also.
No. So suppose the notice of withdrawal is to publish in the official gazette, who should be the right institution? Or who should be the right authority to publish this? Either the High Court or the Election Commission?
The High Court, Your Lordship.
The High Court.
Yes, Your Lordship.
Are you very sure?
Yes, Your Lordship. And only after withdrawal is granted, Lordship. Now the ECI can publish in the newspaper notifying the withdrawal of the EP, Lordship.
So this means that actually the notice has to be issued to the opposite parties. Correct?
Yes, Lordship.
Because actually the notice of withdrawal shall be published. So this notice, which this court issues on the basis of this application, will be published in the official gazette.
Lordship.
Correct? And that publication has to be done by the High Court,
Yes, Your Lordship.
by the registry. And only thereafter, if the application is allowed, then the Election Commission will publish in the official gazette.
That's correct, Your Lordship. That's
Yes, Mrs. Siti, are we on that line? So let us So we go accordingly. Okay, heard Mr. Puseko. The learned counsel for the
Applicant election.
applicant. And Mr. C.T. Jamir, the learned senior counsel for the respondent. Number 1. What about 2?
Yes, not represented.
Stop. The respondent number 2 is not represented. Stop. This application has been filed under section 109 and 1010 of the representation of the people's of the Representation of the People Act 1951 and Order 23 of the Code of Civil Procedure 1908, praying for withdrawal of the election petition number 2/2018. Mr. C.T. Jamir, the learned senior counsel has no objection to the withdrawal application, but he submits that the procedures for withdrawal of election petition as provided for in section 110, clause 3B, correct? May be followed to effect the withdrawal. Stop. In terms of section 110B, there with notice of withdrawal No, in terms of section 110, clause 3B, the registry of this code is directed to publish the notice of withdrawal in the official gazette. As well as in any two local newspapers which has wide circulation in the state of Nagaland. Stop. The steps for publication of the notice of withdrawal in the official gazette, as well as in the local newspapers, as well as in the said two local newspapers, shall be undertaken within a period of 10 days from today. Okay? Stop. Lease the keys along with the notice of withdrawal published in the official gazette, and also the newspapers where the withdrawal notice is published. Will it do? We will let them list only after they have published in the official gazette as well as in the paper. Okay? Okay.
Course of publication may be formed by the petitioner.
Okay, you are the person who is actually, so you are right.
Rather, it should be a heavy cost to us.
At least the registry should be grateful to you. The last line. The cost of notice for withdrawal shall be borne by the petitioner. Acha, just heard Mr. You just show Mr. City then. Senior. Regarding respondent number 2, just have a look, Mr. City. The cost for the publication of the notice. Last line, na? The cost for the publication of the notice shall be borne by the petitioner. I think since we are now publishing notice, I think that will serve the purpose.
Lordship, yes.
Okay. Call this another. List, we will list all this case, and then after this exercise has been completed, then while disposing, we will pass order on all this.
Lordship,
Yeah.
163, IA 163 is listed, Lordship, so.
What is 163?
IA 163 is for praying for direction to allow the EVM, electronic voting machine, and VVPAT to take out from the strong room.
Should we not pass the final orders after this exercise is completed?
Since
That will be taken up together.
So that on the same day we can actually dispose all this, and then we can also issue a direction in 163.
Lordship.
Okay.
Yes, Lordship.